Despite the Supreme Court granting, vacating, and remanding review of a magazine ban case, a lower court continued its defiance by now upholding the magazine ban and at the same time striking down a narrow aspect of a state's rifle ban. And now this defiance is up for review once again. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of the channel, which is Brownells. You guys know that Brownells is an amazing company. They're pro Second Amendment, pro freedom. They support what we do here on the channel. So if you're interested, check them out. They also have a code Scholar10 to get 10% off of any of your guys' orders. Again, amazing company, great people over there. Go check them out. As I mentioned in the intro, in this video, I'm going to be discussing two critical cases which challenge a state's ban on rifles and magazines. This magazine ban case was recently granted, vacated, and remanded down to the district court for a new decision in light of what the Supreme Court said in the 6-3 Bruen decision. Well, that district court recently issued a decision in two consolidated cases, which are the A&J RPC versus Platkin case and then also the Cheeseman versus Platkin case. And in that ruling, the court came to the most perplexing and outrageous Second Amendment analysis that I've really seen in a long time. The court found that the state's ban on Colt AR-15s is unconstitutional and must be struck down. However, at the same time, it decided to rule that any other aspect of the state's ban on rifles or so-called assault weapons, didn't need to be ruled on, that they wasn't going to look at it. And then at the same time, it upheld the state's magazine ban, essentially finding that magazine restrictions of magazines that hold more than 10 rounds did not violate the Second Amendment. This egregious decision has now been appealed to the Third Circuit Court of Appeals for reversal. This is a critical challenge that is necessary to undo this clearly incorrect and outright defined decision that was issued by the lower court despite it getting this case on a GVR. When it comes to the magazine ban, back in 2018, New Jersey passed Assembly Bill 2761, banning the possession of firearms magazines that have the capacity to accept more than 10 rounds. In August of 2018, the district court denied A&J RPC's motion for a preliminary injunction, applying what has now been found to be the flawed two-step analysis. A&J RPC appealed that, and it went to a divided panel in the Third Circuit, who ultimately upheld what the district court said. The case then returned to the district court where a motion for summary judgment was granted in favor of the state of New Jersey, so the court there upheld the magazine ban and also the rifle ban. That then led this case to make its way to the Supreme Court for the first time back in 2022, and ultimately what ended up happening is the Supreme Court issued the Bruen decision, and then they decided to grant, vacate, and remand this case here, the A&J RPC case, back down to the district court for a new decision in light of Bruen, because there the court had outright rejected the two-step approach as flawed, and that's what the court had been relying on. The lower court, both the district court and the Third Circuit, had relied on intermediate scrutiny and the two-step analysis. This case again went in the hands of the district court, and the district court then consolidated multiple cases and decided to rule on both the state's magazine ban and rifle ban as well. Now, in this decision, the district court showed how it was not going to faithfully apply Bruen in the decision there, and the judge essentially believed that the Supreme Court got the analysis wrong in Bruen. So in his new decision, the district court judge stated that it's hard to accept the Supreme Court's pronouncements that certain firearms policy choices are off the table when frequently radical individuals possess and use these same firearms for evil purposes. Now, despite that, the court stated here that it was bound by what the Supreme Court said, and as a result, it issued kind of a hodgepodge decision, kind of protecting only limited sets of rifles, but at the same time rejecting review of any other firearms and also upholding the magazine ban. When it came to rifles, the judge found that given the variety of firearms regulated by the law here and the nuances that each individual firearm presents, the court's analysis of this law is limited to the firearms which the court has been provided the most information, the AR-15. So the court decided to arbitrarily limit the review to only AR-15s, to the Colt AR-15s, and ignored all the other aspects of this law which restrict other semi-automatic rifles and other firearms like shotguns and pistols. Then when it came to review of the magazine ban, the judge did everything possible to twist Bruen to meet the goal of upholding the magazine ban. The judge found that magazines are arms within the meaning of the Second Amendment, and that's precedent in the Third Circuit, so the judge had to follow that. He also found that magazines are clearly in common use. So you would assume that if the judge found that these are arms, that they're in common use, this should be an open and shut case. But then the judge deployed what he called the more nuanced approach based on new societal concerns, and essentially he used that to find that magazine bans are constitutional. So in the decision, the judge strikes down only one aspect of the assault weapon ban, specifically just to AR-15s, and then he avoided ruling on any other aspect, and then at the same time he upheld the magazine ban using the more nuanced approach. But now this horrible decision is being appealed back to the Third Circuit Court of Appeals, and this is good because it's also on a final merits. In the appeal, the plaintiffs here argue that the court started off on the right foot, holding that New Jersey's ban on AR-15s, America's most common civilian rifle, is unconstitutional, but the court then arbitrarily cut plaintiffs' challenge to all the firearms, rifles, pistols, and shotguns in New Jersey, and all the things that New Jersey outlaws as assault weapons, down to just the most popular one. That was inexplicable. To be sure, plaintiffs sometimes use America's most popular civilian rifle as an exemplar of the kinds of firearms that New Jersey prohibits and encompasses. But that in no way negates the pages and pages of summary judgment briefing, expert declarations, and pleadings that the plaintiffs supplied addressing the full suite of firearms the state has banned. Meanwhile, as to magazines, the district court correctly held that the banned magazines are arms covered by the plain text of the Second Amendment. It recognized, too, that they are in common use for lawful purposes. But things went south from there. In attempting to apply a nuanced version of analogical reasoning, the court suddenly, and without explanation, held that the state's ban on possessing these arms was merely a restriction on how people may use them. The plaintiffs further flesh this out in their recent brief by arguing that New Jersey bore the burden to prove that the firearms and feeding devices it has banned are not in common use. It never even tried to make that showing below, and it does not seriously try to do that here in this appeal. It instead asked this court to discard the common use tradition in favor of deferring to the legislator's assessment of the suitability of the weapon's features for self-defense. It should go without saying that this court cannot simply ignore binding Supreme Court precedent, but even if it could, that argument finds no support in the historical record, which reveals virtually no efforts to ban common arms just because a legislator deems them too dangerous for law-abiding citizens. As the historical record confirms, while the Constitution leaves states a variety of tools for combating the problems that are ailing New Jersey, the enshrinement of constitutional rights necessarily takes certain policy choices off the table, and these include the absolute prohibition of arms in common use for lawful purposes. They argue that all of that suffices to doom both New Jersey's firearms ban and its magazine ban. So the plaintiffs in this case have now taken this case back to the Third Circuit, and they are trying to show that the court down below, absolutely got this wrong. They came to an absurd decision and it needs to be reversed. It is very obvious that the district court knew that they could not completely avoid the Bruen decision, that they had to follow some of the analysis, and especially they had to do that since the A&J RPC case was expressly GVR'd back to it in light of Bruen. But the judge essentially did everything in his power to limit the 2A win, and he tried to limit it by twisting and ignoring the Bruen decision, and tried to limit the review only to AR-15s, ignored all other aspects of the assault weapon ban, and then he did everything to twist Bruen to still try to ban magazines, even though he had to acknowledge that magazines are arms, they're in common use, but then he tried to apply the nuanced approach to reach the decision that he wanted. So this is a critical final merits appeal that is now in front of the Third Circuit. The Third Circuit kind of has a mixed track record when it comes to Second Amendment cases, but recently the en banc panel has been kind of favorable in some rulings like the Range versus Garland case, and that's also cited in this lawsuit in favor of the plaintiffs. So in many ways, since Bruen, the Third Circuit has been forced to issue, favorable pro 2A decisions, and even in this horrible decision, the lower court judge was bound in some ways to still have to apply Bruen, and he tried to limit it as much as possible, but it still led to a slight 2A win. So we're going to see how this develops, and as we get more information, I will let you guys know, but this is a critical case. It's a final merits case dealing with both a rifle and magazine ban, challenging the state of New Jersey's outright ban, which could impact other states like California, New York, Illinois, and others. So this is an appeal we're going to be keeping our eyes on. As I get more information, I'll let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you guys for watching. Don't forget to like, comment, subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.